I am Richard Ruddy. Welcome to the Probate Nation. We continue tonight with our series on obtaining the authority as a guardian or conservator for an adult living in the city of Alexandria. Part one of this program, we learned about the legal process to acquire that authority as a court-appointed guardian and conservator if your loved one does live in the city, including bonding requirements, what needs to go into the pleading to the court, the role of the guardian ad litem, and the court hearing to act on your request. Tonight we're going to cover your visit to the probate office to get officially appointed and learn about your ongoing reporting obligations thereafter. We are fortunate to have back our guests, again, local Alexandria attorneys with experience in these matters, and they will guide us, serve as our guides, in completing the discussion about all that is involved in the living probate train ride you will be embarking on once formally appointed by the probate office. Our first guest is an attorney with the Westreich Law in Alexandria. His practice focuses on estate planning, estate and trust administration, adult guardianships and conservatorship, and fiduciary and civil litigation. He represents the Alexandria Department of Community and Human Services in many guardianship and conservatorship matters. Our second guest is an attorney with the law firm of Christopher Mays, PLC, also located in the city of Alexandria. His practice focuses on estate planning and administration, guardianship, conservatorship, and probate issues, Medicaid planning, as well as preparation of premarital and marital agreements. In addition, he serves as a guardian ad litem for incapacitated adults and represents clients in involuntary hospital commitment hearings. He has been recognized as a top lawyer by Northern Virginia Magazine and Super Lawyers. Please welcome back attorneys Jonathan Westreich and Chris Mays. Jonathan and Chris, thank you so much for coming back to help us finish up this part two of the program. You know, we're going to jump into, probably the thing that people don't really like to talk about, which is what's it going to cost to go through this process. And Jonathan, there are a host of fees and costs that can and do arise in the course of this whole process. Can you discuss who pays these fees?
So the petitioner's legal fees, they'll need to be advanced by someone at the beginning, but they can be reimbursed out of the ward's assets once the conservator is appointed. Similarly, the guardian ad litem is paid out of the ward's assets unless the ward is indigent, in which case the Commonwealth will pay. And then there's fees when you qualify in front of the probate clerk. Usually the conservator will advance those fees as well, and then they are reimbursed from the assets of the ward.
Okay. Now, are the fees for the attorneys, at least, are these typically automatically accepted by the court, or is there some sort of a review process that goes on?
So the court reviews them. When you have the hearing on the petition, you have to submit the invoices in advance. The court does review them. Also, the guardian ad litem looks at the petitioner's attorney's fees, and the petitioner's attorney looks at the GAL fees to make sure that they're reasonable. If everybody agrees they're reasonable, it's rare for the court to reduce them. But if anybody has any objections, the court certainly has the authority and certainly would reduce any fees that appear to be out of the norm or unjustified.
Okay. Chris, I'm going to come to you. At the beginning of the first show, a part one show, we talked about some key legal documents that folks should be sure to execute, documents that might eliminate the need to embark on the living probate train ride. Can you mention those documents again?
Sure. That's going to be the general durable power of attorney for finances and the healthcare power of attorney and advanced medical directive. These are going to be big cost savers.
Now, every day, people are especially cost conscious and thrifty. In your experience, would you estimate the cost of preparing these very basic estate documents are more or less than the costs and fees that would arise if someone had to go to court to get appointed as guardian or conservator?
Oh, absolutely. So preparing the documents and having them prepared is going to always cost significantly less than having to pay an attorney to go to court and do what these documents basically do. And
of course, there is, in addition to those costs, there is, of course, the cost of the ongoing cost if you have a conservatorship that's going to occur every year that will also be added to that cost if you don't have these documents in place. Jonathan, let's go to you and talk about the appointment process in the probate office. Once the petition is ruled on by the court, what needs to be done to get the petitioner formally appointed as guardian and/or conservator?
You have to have be appointed by the clerk of court. And in Alexandria, there's an email address where you email them and ask for an appointment. And they can do this both remotely or in person. There's you have to get a bond for the conservator if one is required. And there's a few small fees that have to be paid to the probate clerk as well. But the key thing is you have to contact the probate clerk to get an appointment.
Now, Jonathan, are there any common problems that occur after the court order is entered that could prevent somebody from getting qualified?
The biggest one is a bond for the conservator. It is always required if there's any assets and if the person proposed as conservator can't get a bond, that is a barrier. You'd have to go back to court and get somebody else appointed as conservator. And the common reasons people can't get bonds is either they have bad credit or they have some judgments against them, or in some circumstances, if there's lots of family arguing over who is the appropriate person, that can also sometimes lead to the insurance company not issuing a bond.
Okay. Now, Chris, I'm going to come back to you. For conservator appointments, we discussed the need for a bond to be issued by an insurance company. Will that representative need to be present when the conservator is appointed?
No. So usually the arrangements for that bond are going to be made in advance. Then at the appointment, you'll swear in, you'll get your certificate, and the bonding agent will sort of take care of everything after the appointment. And that sort of concludes it.
Okay. Now, how is the amount of bond needed determined, Chris?
So when we're talking about bond for a guardianship, the standard bond that you'll typically see is $1,000 with no surety. For the conservatorship, the amount of the bond is going to be based on the respondent's estate or the assets of the respondent. Usually that's going to be an amount 1.3, 1 1/3 times the estimated value of the estate.
Okay. And we sometimes don't always know with great accuracy all of the assets that need to be bonded. So we'll talk a little bit further on down the line how that might need to be adjusted. So Chris, what kind of document is given to show that I've been appointed as guardian or conservator?
So it's going to be a certificate of qualification. It's issued by the clerk. It has a raised seal on it. And this is essentially your badge of authority that allows you to go conduct your duties.
Okay. Jonathan, does the probate office provide any written guidance or instructions to the guardians and conservators who've been appointed?
Yes, they do. There's a packet they give out that has copies of the Supreme Court forms that are required to be filed with the Commissioner of Accounts. The Commissioner of Accounts is a court officer who supervises conservatorships. And there's lots and lots of detail in this packet from the probate clerk to explain the requirements of your job and how to meet them.
And I think we probably answered this question, but I just want to confirm, does the Commissioner of Accounts himself or herself provide any written guidance or instructions to those appointed as conservator?
As part of the packet that you get from the probate clerk was prepared by the Commissioner of Accounts. So the Commissioner of Accounts is very, very helpful. They want you to do it right the first time. And if you have any questions, they're very, very helpful here in Alexandria. They will answer your questions, particularly if you approach them in advance. If you come in later when things are late, that's a little more difficult.
I have to echo your compliments to the Commissioner of Accounts office in Alexandria. I have found them to be just that, extraordinarily helpful. But you have to be forthright with them about what your problem is, and they will generally be able to help you solve it. Now, what are some of the common reasons why qualification cannot proceed, Jonathan?
The biggest one is the lack of a bond. That's why it's so important to contact a bonding agent in advance, even before you file the petition, or certainly before the order is entered. It just makes things really complicated if if you're unable to get the bond. You can know that pretty quickly once you submit the financial applications to the bonding agent.
Okay. So let's turn now to some of the reporting requirements that have to be complied with after you've been appointed and you've received your certificate of qualification. So Chris, we have the Department of, I'm Guardian. What kind of filings and reporting obligations do I have as a Guardian to the Department of Social Services?
Sure. So the main one is going to be a guardianship report, and this is on a form that's provided by the state, but it requires a detailed amount of information about the mental and physical health of the respondent, who's providing services, whether those services are appropriate and doing a good job for the respondent. It's going to have to provide information about hospitalizations, names of persons who have access or who have had access restricted, all kinds of information. The initial report's going to be due 6 months from the date of qualifications, and then every 12 months after that.
Okay. Now, as a conservator, tell me a little bit about the reporting obligations to the Commissioner of Accounts, who oversees all of these funds that the conservator is taking care of.
Sure. So the Commissioner of Accounts, you're going to file your inventory. That's going to be 4 months from the date of qualification. That's going to list all of the assets, the accounts, real estate, including real estate outside of Virginia, that the respondent owns. After that first inventory is filed, at 6 months, you're going to have the first accounting. And so this is basically where we show all of the money coming into the estate, all of the money going out, and sort of documenting all of the expenses that we pay. Once we file that initial accounting at the 6 month point, then we have 12-month filings every year thereafter.
Okay. Now, Jonathan, the reporting obligations that Chris just talked about to the Commissioner of Accounts is often what gets a conservator in trouble and leads to their removal or to lawsuits against them. So take a few minutes here to talk about some of the key do's and don'ts that every conservator should follow.
The most important thing is record keeping, record keeping, record keeping. You have to keep records not only carefully and completely, but in a way that you can find them to prepare the reports. And they're audited to the penny. So if the conservator pays a utility bill, the auditors need to see a utility bill for the address of the property owned by the ward and a check cleared out of an account in the ward's name to the utility company. It is audited that closely, and it's so important to keep those records from the very beginning. If you don't, it's much more complicated and much more expensive to recreate them later. And then you really have to pay very careful attention to the deadlines for the commissioner's reports. Missing those deadlines will get you in hot water with the commissioner. And there are things that make sense to you in normal practice, but don't work once you're conservator. And it's really important to have some professional guidance on what you can and can't do. You mentioned you can be removed as conservator. That's always a risk. You can have judgment entered against you if you can't account for money. And I have had instances where conservators have been criminally prosecuted for misconduct in their role as conservator. So it's really important to get this done right the first time. And it's record keeping and then talking to someone as you're going along to make sure you're doing things correctly.
So Jonathan, in that line of thought process though, what do you suggest people do as far as the type of bank account that they should open up in the name of the conservator? Should they be looking to get account statements that give them copies of canceled checks, or should they just be making copies of checks as they write them, or how should they do that in order to document things for the commissioner?
So the first thing I always tell people to do is close all the existing bank accounts. And that's to make sure there's no automatic debits that happen that you don't know about as conservator. And then you need to open a new account, and I recommend at a different bank that is in the name of the ward by the conservator, and you must get copies of canceled checks. because you have to show those canceled checks, copies is fine, of course, to the Commissioner of Account on the audit. For the investment accounts, you don't need to close them. You do need to retitle them in the name of the ward by the conservator, and make sure the investment companies know that they can only make transactions on your instructions as conservator.
So, and there's much more to this. I know, John, you could talk for hours about the issues that can come up with. I bet I'll add this one final thing and get your feedback before we go to the next topic area. If the commissioner's office does write to you and say something's not done correctly, or they send you a letter that says we have some concerns about your accounting, should you pay attention to that letter?
Oh, absolutely. If you get a letter like that, and it happens all the time, it's not something to be upset about, and you will not, frankly, get in trouble usually if you go right to the commissioner's office and say, tell me how I can get things straight with your office. They will be very, very helpful. If you're missing records, they'll tell you which records you need. If they think you need professional help, they'll tell you, they can't tell you who to call, but they'll tell you that you really should get a professional involved.
That's all good thoughts. Let's move to the next topic area. Chris, I'm going to come back to you and talk about some of the common problems and pitfalls that you've seen over the years when undertaking to get appointed as a guardian or conservator.
So one of the big pitfalls I've seen is a lot of people, again, with the DIY, people with the internet think they can kind of look things up, learn it as they go, especially when we're talking about some of the filings with the commissioner, the record keeping that we have to do with conservatorships. There's a lot of steps to it. There's a lot of information. And if you're not doing it right the first time, and if you're not setting everything up properly, you're kind of creating problems for yourself down the road. So getting professional guidance early on is usually very critical to avoiding problems.
Jonathan, how about yourself? Some closing comments and comments from you, some practical advice about the problems that you see people running into when they both apply to be a guardian or conservator, or when they begin to take over and start to operate.
So there's two big things we actually haven't talked about tonight as serving as a conservator that are really important. One is taxes, and the other is real estate. It's very common for someone who needs a conservator to not be current on their taxes. And you as conservator have to get them current. And that will require getting records from the IRS, usually with the assistance of a CPA. And that's something that I have to do frequently, and I commend that to everybody. The other one is real estate. In Alexandria, when you qualify as conservator, you do not have authority to sell real estate. You have authority to list it for sale, but you have to come back to court and get permission to sell the real estate. And the court requires specificity, meaning you have to get permission to sell this particular property to this person for this amount of money. That's to make sure there's no sweetheart deals going on with real estate. So taxes and real estate are a big issue, but the record keeping, I can't emphasize that enough. That's the most important thing.
Yeah, I would just piggyback on your comment about taxes. You know, so a lot of people will have made estimated payments, but if they don't file that tax return within a certain period of time, they may find that they don't get the refund that might be due to them. And so as you taking over as conservator, you have to get on top of that really quickly, as you have suggested, just to assess just where we are with returns and whether returns have been filed. So we don't find that we lose a $20,000 estimated payment that's been taken out of pension plans as part of the normal process of delivering your pension payment. So yes, the taxes is a big issue.
And in Virginia, there's a failure to file penalty, even if you don't owe taxes. So it's really important to get right on top of that.
I agree. And getting a CPA involved is a good idea. Let's go to closing comments. Jonathan, I'm going to stay with you because I think you've got you're in the flow of feeding us information right now. Some final words and thoughts, practical advice, suggestions about obtaining and being a guardian or conservator in Alexandria.
So before you decide to seek to be guardian or conservator, you got to make sure you really want the job. as guardian, you have to make difficult decisions, healthcare decisions for somebody else, and you have to be ready and willing and able to make those decisions. And if you're going to be conservator, you have to understand there are very careful reporting requirements. You're controlling somebody else's money, and you have to have the ability to do that and the desire to do that. Those are really, really important. And if there's family tension or conflict, it might be wise to have an independent person serve as conservator. Many times it's better to have family as guardian making healthcare decisions, but sometimes an independent person, and it doesn't have to be an attorney, can serve as conservator. And again, record keeping, record keeping, record keeping. I can't say that enough.
Chris, how about your final thoughts as we reach the conclusion of these two shows?
Well, just to sort of piggyback on what Jonathan said, there is a lot to serving as guardian. And, as he suggested, sometimes it can be too much for a family member and you may have to look to a professional. But even if a family member is going to serve, there's additional help in the form of elder care consultants and other experts to sort of help you process information and give you guidance. So always sort of building a team of professionals to sort of help take you where you want to go is always going to be the best course of action.
And do you find that sharing information about someone's health and the medical things that are going on in their life with the family helps to dampen down any concerns that the extended family might have?
Oftentimes that can be the case. When we're talking about medical issues and illness, it can be a very contentious subject. But yeah, usually the more information you share, the better. Okay.
Well, I think that's about everything I can think of at this particular point. Guys, I tell you, it's been just a wonderful, it's just bountiful information that I got about all the things that go on in the city of Alexandria and what people should do. And we're very grateful for you guys taking the time. Great public service to everybody in Northern Virginia and for everybody who's part of the Probate Nation. So again, I want to express my deep appreciation. Thank you for taking the time to help us out here.
Thank you.
Thank you. You're more than welcome. I enjoyed it.
If you need to petition the Alexandria Circuit Court for the legal authority as a guardian and a conservator, what our guests shared over the course of two shows should be incredibly helpful. Clearly, there are numerous steps to take to get your request to court so a judge can rule. And many of those steps deal with legal requirements both in the documents filed as well as key decisions that need to be made. My guiding concern as we wrap up these shows is the following. Seeking this authority is not an undertaking you should handle as a pro se petitioner. There simply are too many decisions to be made, too many legal steps that require legal knowledge, and often this is an emotional time for you, the family, and the person you are seeking legal authority to care and act for. So I urge you to seek out the assistance of an attorney with experience in these matters before you purchase that ticket to board the Living Probate train. You'll be glad you did so. This concludes our show this evening. We hope you found it informative. Just a reminder that replays of this show can be viewed on the Probate Nation website and YouTube channel. And if you want to receive monthly tips on guardianship, conservatorship, and probate matters, please sign up for the free Probate Nation newsletter. Until next time, I am Richard Ruddy, and this is the Probate Nation.